I recall that there's a list of arbitrators, and some of them tend to be quite specific about the language.
Hello and welcome to the first ever episode of the ArbCast podcast. This is a podcast on all things related to international arbitration. So, if international arbitration interests you, do keep an eye out for this podcast because I have some very interesting guests lined up from the industry with whom I'll be discussing very relevant and contemporary issues pertaining to international arbitration. And for this one, I'm joined by a friend of mine who I met in Europe last summer. He goes by the name of Moises. Moises is pursuing his advanced studies in international private law. Previously, he's an alumni of the Hague Academy of International Law and has also attended the London School of Arbitration. He has also taught international private law in Venezuela. And the most impressive thing about Israel, on a lighter note, is that in a city like Paris, somehow he manages to focus on international law. So his dedication to international law cannot be questioned. And that's on a lighter note. Well, thank you so much, Moises, joining me on this particular podcast for my very first episode on a Sunday. And
Well, the pleasure is mine. I mean, I was quite surprised when you told me for the first time. I mean, given your expertise, I mean, I would like to join you to join to my podcast. I was like, okay, this is surprising. Well, here I am. Glad I'd accepted.
yeah, thank you so much. And thank you for being dressed up. I mean, evidently you're suited up from top to bottom, I would assume. Not wearing your boxers there, aren't you? In any case,
Well,
so today, since it is the first episode of this podcast, which is on arbitration, let's talk about the origins of arbitration itself. So we do know that arbitration stems from Lex Mercatoria, which is the law of merchants. But in the modern day, if we were to correlate arbitration to any but international arbitration to any subject, it ought to be private international law, because the principles of arbitration, which is party autonomy, stems from private international law. And but speaking of private international law, I there is a lot of misconceptions that exist because when we think of international law, we think of the International Court of Justice, we think of United Nations and these international bodies. However, private international law has nothing to do with it. And all these things that we think about international law, international affairs, stems to public international law. So my first question to you would be, do you think that private international law has not been given as much importance as it should have been? And there is some confusion related to private international law with public international law. And if so, why is that?
well, I mean, a straightforward answer definitely is yes. But why happen? Why is that? Because I mean, even for us lawyers, private international law tends to be quite complicated. I don't know if you recall or if you were at Professor Sanovetti's seminar at The Hague, but she told us that private international law in general is quite baffling, and only an elite of students and professionals as well can understand it. Okay, coming from where I come from, Venezuela, I recall that most of the students, me at the first moment, I was quite baffled about the subject because it was the first time that someone talked about the possibility of applying foreign law. We were like, is that possible? But yeah, it is possible. But I mean, what people tend to think about, seems to think about international law is what you said, but sometimes the private international law, people think to think that, oh, there are states involved and all that. No, the international in private international law makes reference to a foreign element, okay, foreign to a given legal system. That's all. I recall that Professor McLachlan at our first session. in the winter courses, which I had the honor of attending for the first time, and I recall that I was the only Venezuelan attending. He told us that private international law's object is cross-border transactions. I mean, one may agree or not to that definition, but yeah, basically it's that. Okay, cross-border transactions dealing with cases having a foreign element. Okay, and as I just said a couple of minutes ago, foreign element is a strange element to a legal system. Okay, maybe nationality, maybe domicile, or if there is a choice of law or choice of jurisdiction clause, which is yeah, choice of jurisdiction clause. That is also a foreign element to take into account. For example, when two parties sign a contract and they decide a given jurisdiction to resolve the dispute, that is also a foreign element. But remaining to the question, I would say that, yeah, it's because it's quite complex. The complexity makes it difficult for people to understand. And I recall that in one of the law is actually the most baffling branch of legal science. But yeah, I mean, it's because of that. But if one with discipline and dedication tries to understand it, they will understand it.
Yeah, most certainly. And especially in today's time when, the world is less sovereign than we think and more integrated than we think. Exactly, right? So that is why this field of private international law becomes very, very important. And notwithstanding it being difficult or not, as lawyers, we must equip ourselves into understanding these principles of private international law because no matter whether we are disputes lawyers or transactional lawyers, we will be facing any foreign element in our cases, and we cannot be blank at that point. So yeah,
Yes,
rightly
I completely
stated
agree.
by you that it is baffling and can be complex. Though notwithstanding it being complex, my next question is how would you dumb it down to the best extent possible and explain to our audience that what is private international law, Moises?
Well, academically, technically put, it's a branch of law that comes into play when a foreign element is present in a given case. But that's, yeah, very academic. So if I had to explain it to a layperson, I would give more or less the same example that a former judge Gonzalo Parra Aranguren, Venezuelan, and the second Venezuelan to reach the ICG, notwithstanding that his education was in private international law. Well, he used when he lectured at The Hague the example of a traffic accident. But I would like to use rather the example of a divorce, of marriage divorce, which I think will illustrate very well the components of what we normally see in private international law. Let us suppose that one of us is getting married, for example, in London. Okay, everything is okay. London, English law allows it because there are some countries that don't allow people getting married if they're not residents or they are nationals. Okay, let us suppose that English law authorizes this marriage. Okay, and afterwards, after the marriage, you move, let us say, to Spain. In Spain, you both couples share a couple of years, but all of a sudden, love is gone. It happens, and one of each of you decide to return to your country, to your respectful countries. Your case, India; my case, Venezuela; and your couple, Germany. She decides to sue for divorce, and let us suppose German courts are competent. Because I don't know German private and German law. But the thing is, will that decision be enforceable in India? We don't know. So with this example, we see, for example, the problem of jurisdiction. I mean, who is going to be the competent court to decide upon the divorce? But the court deciding upon the divorce does not mean that the German courts are going to apply German law, because there is no proximity. Because private international law is constructed upon deciding a case upon proximity. I mean, at least Savigny's tried to localize the relation and apply the law which is more closely connected to the situation. Okay? So, which law is going to apply the German judge? We don't know. I mean, that is going to be decided upon the conflict rules, which is something that I'll explain later. And then, when a judgment is rendered, the recognition and execution of a foreign judge or of a foreign judgment. Normally, those are the three issues that private international law deals with. In France, before the European regulations and visa liberalization, they took a broader approach, including the condition of legal aliens, of aliens, yeah, and nationality. But most of, I think, I mean, I may be mistaken, but I think most of legal systems only evaluate these 3 points, including my country as well.
So like you mentioned, private international law is when two different jurisdictions are involved, and simply put, when there's a foreign element involved. So when there are two different jurisdictions, you're dealing with two different set of laws, but you cannot have that same particular dispute being trial in those two different jurisdictions. It has to be done in only one jurisdiction. But if there are two different legal systems, why would they use a foreign law when they are not well versed with it? What is it? What is the principle that drives them to use foreign law in a court which does not recognize that particular legal system?
Well, before entering into choice of laws, I mean, conflict of jurisdictions must be resolved. And I think you mentioned about something about two countries deciding upon a same subject, I think.
Same dispute.
Well, actually, that's not that strange, because as Thomas Mann, F.A.N. Mann, which lectured at the Hague Academy about the doctrine of jurisdiction, puts it, legislative jurisdiction is actually concurrent rather than exclusive, insofar as when there is a foreign element involved, multiple jurisdictions can apprehend one-side case. How to deal with that situation, for example, because you have to solve conflict of jurisdiction before going to conflict of law.
Just to interject, allow me to interject. Basically, what my question is that does any national domestic court have an obligation to consider a foreign law when it has a foreign element? Does an obligation exist?
Not really. And there is an interesting debate about it, because, for example, you can correct me if I'm wrong, common law systems do it on the basis of comity. Well, that concept, I come from a civil law jurisdiction and I'm studying at another civil law jurisdiction, which is France. We don't act upon comity. I say that the basis for us is justice, and the proximity to a situation, to another situation. For example, if I want to apply my own law to a situation that has no connection with my jurisdiction, that can be perceived as unfair.
Correct.
And normally, no, there is no obligation to do it. I mean, I think there are some countries that apply their own law, but for example, in most of Latin American countries, they do it. In fact, there is a law, a private international law act that designates for conflict of law rules, which is the law applicable. Some of them, if not most of them, because the proof of foreign law is something more of common law countries, even establish the obligation of a foreign judge to apply foreign law. I mean, there are some limitations like public policy, overriding mandatory rules, etc. But in general, yeah, they apply foreign law.
Yeah.
If they do it well or not, that's another issue. But for example, I'm going to speak about my country. There is a legal obligation for the judge to apply foreign law because it's enshrined in the Private International Law Act of 1999, which was drafted by Gonzalo Parra, which I may remind, he ended up being a judge in the ICG. Even the judge even has the obligation to look for the tenure and the meaning of a foreign law. I mean, it is easier, for example, when the Venezuelan choice of law, conflict of law rules design a similar system. But what happens when we designate a completely unfamiliar system? Well, in principle, in principle, the judge will have to apply it. Well, then we have other considerations of public policy, and which is a mechanism to exclude the application of a foreign law with it collides with the fundamental principles of foreign, and we will have overriding mandatory rules considerations. But that's afterwards. I mean, that's afterwards. In principle, most of the legal system, unless I'm mistaken, apply foreign law, and they enshrine it as an obligation in their act. Common law system works upon committee, but
Yeah. So in private international law, to determine what law will be applicable, there's a test which I think you have briefly touched upon. The test is known as closest connecting factor test. Now, could you just elucidate what the closest connecting factor test is?
Okay. Well, we'll have to talk about Savigny in this case because it was a companion. It was a revolution when he invented the choice of law rule, because before that, the law was designate its own chance of application, its own scope. When Savigny decided the first choice of law rules, he thought, okay, because of considerations of fairness and justice, we have to localize the relation rather than designate the scope of the law. Okay, so the closest situation will be the law more suitable to the situation will be that of geographically where the situation is located. For example, in the example of the divorce, and to illustrate, Spanish law will be applicable because it's where the place where the spouse lived in, they're familiar with it, therefore Spanish law would be more suitable to the dispute.
Correct.
That's what I wanted to say with closest connection.
Yeah.
Well, depending on the legal system, because not all the countries have a choice of law rule.
Indeed, yeah.
I recall the example of the United States, Rick, when there are some states that have choice of law rules, like Louisiana, because they have a civil law tradition, because before they were a French colony, so they inherited the codification. But for example, most of the states, and I recall this from our comparative law course, I don't know if you recall, most of the states utilize the curious approach of the governmental interest analysis, which for me personally is just an excuse to apply your own law.
Correct.
But most of the countries, at least civil law countries, prefer Savigny's approach, while the United States prefers the governmental interest analysis in each of the states because they're federal. So there's in, unless I'm mistaken, there's no a private international law act. Each state has its own conflict of law rules or its approach, basically.
Yeah.
There is a principle called reasonable proximity.
Yeah.
Okay, that is to say that you're not going to draft anything considered exorbitant, for example, only based on the nationality of the parties, that is considered exorbitant. When they draft their own choice of your conflict of jurisdiction rules, I mean, they do it like based on a certain reasonableness. But once again, that depends upon your in a conflict in a common law system or a civil law system. In civil law systems such as mine, well, they when they're drafting, they decide upon is going to be competent the tribunals of the domicile of the defendant, for example. That is considered reasonable. In fact, if we check the European regulations on jurisdiction, which is Brussels 1 recast now, we're going to see that the general rule is that of domicile.
Indeed.
Same rule that Venezuela has adopted in its Article 39
Yeah, just
of
to
the Private
interject, just
International
to
Law.
interject, for you to proceed further, if you could just explain the concept of domicile and how is it different from permanent residence, or is it any different than permanent residence?
Well, it's going to depend of each country.
Don't give a lawyer answer.
In well, in the United States, to be considered domiciled, okay, according to Black Law Dictionary, you have to be physically present and have the intention of being there. In Venezuela, for example, the Article 11, if I'm not wrong, says that the domicile is going to be the habitual residence.
Hmm.
French, they are going to consider that the domicile is where the most important interest located.
Just on a lighter note, that even in conflict of law principles, we have conflict between jurisdictions. No wonder why it's
Yeah,
so complex.
yeah. Okay? I'm going to talk about Venezuela in this case
Yeah.
because okay, they say habitual residence, okay, but the law does not give any hint of how to determine. So you have to, use other codes like tax code act to determine when a person is domiciled. In Venezuela, it would be considered like 186 years continuous or not continuous. You're considered domicile. I mean, it's for a tax law effect, but the doctrine has transposed it to private international law act to consider that someone is domiciled or not. There is a discussion upon, okay, but do you need the intention or not? Most of them say no. But then you have the rules applicable to expatriates and diplomats. In that case, the Private International Law Act says that, well, in the case of expatriates and diplomatics, these rules are not going to apply because it's not considered something of their will. You see? Then the intention is also important when determining the domicile of the person. It's not only physical presence, it's that you want to be in that place.
Correct. Yeah. So, I think so far that we have established that even within conflict of law principles, there can be conflicts between those principles. And that is why, in order to harmonize different jurisdictions, the best way is to harmonize. So, my next question to you is there are certain organizations such as the SCCH and UNDETROIT that harmonizes different aspects of private law. So, what do you think? Are they beneficial? And how is it that they can make private international law a more efficient field?
Okay, well, unification at the outset it's very difficult because you have cultural considerations. Well,
Indeed.
mostly in family law. That's why there is no European regulation on choice of law on family matters. There is only in divorce, and not all the European Union members are bound to that regulation because it was because of an enhanced cooperation, Rome 3, I recall. But yeah, I mean, for example, in economical matters, traffic accidents, I mean, I think it's a very useful tool because it's going to be help to predictability, okay? To have more predictability and certainty, which is quite needed in this field.
Indeed, yeah.
I'd like to use the example of Latin America because we have ratified some of the Hague Conference. We have ratified some of the Hague Conference treaties, conventions, but not all of them.
Mm.
Not all of them. Like international the protection against child abduction, we have ratified. The one I forgot the word. I'm sorry. The one installing the apostille, eliminating legalization, for example. Yeah, but for example, in choice of court agreements, we haven't ratified it. And recognition and the 2019 recognition on enforcement of foreign judgments, we haven't ratified it, not even signed it, anything. Okay, but I think it's quite useful. Yeah, it's quite useful to have a unified
Indeed.
body of
Yeah.
law. In France, well, depending of the professor or whoever you ask, you're going to be against or in favor. In France, for example, there is no codification. I mean, excluding some articles in the Civil Code and the European regulations, there is no unified rules on private international law. Actually, most of the rules in French private international law have been developed by the jurisprudence of the Court of Cassation. We have, for example, the L'arrêt Sheffel, transposing the rules of the civil procedural code to the international order. And most of the choice of law rules were of jurisprudence. But yeah, I think, and probably not, the French professors are not going to agree with me. Codification is quite useful. In Latin America,
Yeah,
we
it
have
is.
some conventions as
Most
well.
certainly it is, yes.
We have some conventions as well, like the Bustamante Code, unifying some rules. I mean, it wasn't as successful as they wanted to be,
Mm.
but there are unification of some rules, even conflict of jurisdiction rules, wasn't ratified by all states, but it's either way quite useful.
Yeah. Yeah, I mean, it's only useful if you have as many jurisdictions ratifying to it, right? And if you have a couple of
Yes.
them ratifying, then it's as good as nothing. So, coming to the next and final segment, which is on careers in international dispute, international private law. So, as a budding lawyer yourself in this field, my question to you is, how do you think if a student is in their undergraduate level interested in this field, how does one go about it? How does one plan it out into making a career? Because it is quite tough to break into different jurisdictions. Are there learning multiple languages beneficial? Are the international moot courts like the WIS moot court, Frankfurt moot court beneficial? Writing publications on international law beneficial? And last but not the least, in fact, the most important, is a master's or advanced study important or essential?
Well, I mean, yeah, always learning different languages is important, notwithstanding English being la lingua franca. I mean, I recall that one of my professors uh, told me once that to be a successful lawyer, the first thing a lawyer needs to learn English. Oh, yeah, he was quite right. And in the fourth place, he located knowing law. But yeah, I think learning language is very useful, not only because, I mean, you're being entitled to perform some comparative law exercise, but also because learning different language will help you to understand different cultures. Because, for example, here in Europe, and from my experience, they are quite similar in most of the things, but not all. Not all. So learning the languages will help to better understand a certain culture, which is quite useful even in arbitration,
Mhm.
because you have parties from different backgrounds. And I recall when I had a PCA lecture at The Hague in winter. I didn't take it in summer because I
Yep.
already know what the PCA was. I recall that there's a list of arbitrators, and some of them tend to be quite specific about the language. I mean, you can ask for someone speaking Greek, but not being a Greek national, having some certain level of expertise. So yeah, I think that the language skills are important, not only knowing English. That's at this stage, that's pretty basic. So I would say, yeah, always try to learn new languages.
Yeah, definitely. And coming to advanced studies, is it necessary, essential, LLM, GD, PhD?
About PhDs, I mean, my diploma now is an advanced diploma in private international law, not properly a master's, but that depends. That depends because I was talking to a friend that holds a PhD from the Geneva Institute. I mean, one of the most reputable
In India.
in the world,
Yeah.
and he was like, okay, because I want to do a PhD, but not now for this reason. He told me, okay, why do you want to do a PhD? Why? Why? Oh yeah, because that will help you professionally. And he told me, no, because you're going to be overqualified. If you want to pursue an academic career, then you do a PhD.
Yeah.
According to him, he wanted to pursue an academic career. But notwithstanding, I've seen some professors being appointed as arbitrators, for example. So the rule is not absolute as one may think, but always pursuing advanced studies, being an advanced diploma, LLM, a JD, it's important. You need to know something. You need to specialize in a certain branch because, for example, arbitration. The arbitrators, for example, are appointed because of the specialized knowledge. Almost because otherwise you would go to a national court. And that's not the idea. So that always try to pursue advanced studies. Not necessarily a PhD. Can be only an NLM or a magister juris at Oxford. But it is necessary to have an specialization on a branch, on a subject. And it doesn't only apply to law, it applies to everything.
Okay.